What does it truly mean to be a citizen of the United States?
Okay.
It's a question, deep in our Constitution, but it feels like it's right back at the forefront again.
It really is. It's a fundamental question about belonging in America.
So today we're doing a deep dive into birthright citizenship. It's a basic concept in American law, or so it seems. We'll unpack the 14th Amendment Citizenship Clause, look at the debates, especially, with recent executive actions and court rulings stirring things up.
It's a crucial discussion, really, for understanding how we define who's in and what that means for the country's future.
Exactly. Our mission for you today is simple. Help cut through the sheer complexity here. We'll look at the history, the different legal ideas clashing, and importantly, the real-world impact of how we define citizenship, especially for kids born here to non-citizen parents.
You'll get a really solid grasp of what's actually at stake.
We've looked at a lot of material legal reviews, government docs, news reports, expert testimony to pull out the key insights for you. Okay, let's start at the foundation. The 14th Amendment Citizenship Clause. Can you remind us what it actually says?
Sure, it says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Pretty clear language on the face of it.
And its original purpose. It wasn't initially about the situations we debate today, was it?
No, not directly. It was added right after the Civil War. Its main goal was absolutely clear then. Guarantee citizenship to the freed slaves, to make sure their fundamental rights couldn't be denied.
A huge step. But the interpretation, that's where things get interesting, especially with that big Supreme Court case, Wong Kim Ark in 1898. What happened there?
Right, Wong Kim Ark, it's pivotal. The court ruled specifically on a child born in the U.S. to Chinese parents who were lawful permanent residents. They said, yes, that child is a citizen.
Okay, lawful permanent residents. But the understanding became much broader, didn't it?
It absolutely did. That ruling has been widely interpreted for over a century now to mean that birthright citizenship applies to basically all children born on U.S. soil. Regardless of the parents' immigration status at the time, that broad reading is what's really being challenged now.
So, subject to the jurisdiction thereof, that phrase in the amendment is key. You mentioned the interpretation is broad, but are there any exceptions generally accepted?
Well, historically, yes. The classic examples are children born to foreign diplomats. They aren't considered fully subject to the jurisdiction because of diplomatic immunity.
Okay, that makes sense.
Any others? The other main historical group was children of Native American tribes that were still considered separate sovereigns, owing allegiance primarily to their tribe. Though it's important to add, Congress later passed laws granting citizenship to all Native Americans born in the U.S.
So apart from those narrow cases, the default has been, born here, you're a citizen.
Pretty much. That's been the status quo based on Wong Kim Ark.
It's fascinating, though, how citizenship itself isn't as simple as it sounds. You think citizen, you think voting right to stay, but it's more complex.
Oh, absolutely. The minimal definition involves the right to stay and eventually the right to vote. But history shows us it's not a fixed package. Citizens have been denied the vote based on race, sex, poll taxes, literacy tests, you name it.
And sometimes non-citizens got rights we associate with citizens.
Exactly. Some states actually allowed non-citizens to vote at certain times, and the U.S. has drafted resident aliens into military service. So yeah, the idea of citizenship, it's definitely more fluid and historically contingent than many people assume.
Which maybe explains why this seemingly settled birthright rule is facing challenges again. It gets right to the core of who belongs.
Precisely. We've seen repeated political pushes to change or reinterpret the Citizenship Clause, specifically targeting children born to undocumented immigrants. Think House subcommittee hearings, the Republican platform back in '96, even state-level attempts.
It's not a new debate, but it feels particularly intense now.
Definitely. And you have strong arguments on both sides. For instance, Professor Christopher Eisgruber defends the current rule. He argues against changing it or moving to a system based purely on parentage.
He talks about a responsiveness principle. What's the idea there?
The core idea is simple. A government should be responsive, meaning accountable, to everyone it exercises general power over. If the government makes laws that affect your life, you should have a say, or at least a path to having a say.
So, birthright citizenship achieves that.
Eisgruber argues it's the best way to implement that principle. Giving citizenship to those born under U.S. jurisdiction ensures they eventually get a voice in the laws they have to follow. He thinks changing it undermines a basic commitment to political justice.
Okay, that's one view. But what about the counterargument, the idea of a parentage criterion? People like Professors Shuck and Smith talk about this.
Right. They argue citizenship should depend more on the parent's status. This often ties into a consent principle, the idea that membership in a community, like a nation, requires mutual consent. The community consents to the individual joining, and perhaps the individual consents too.
Mutual consent. But Eisgruber pushes back on that too, right?
He does. He thinks focusing on government consent is the wrong way to look at it, especially for birthright citizenship. He argues it's really the individual's consent, or lack thereof, particularly the person being burdened or excluded, that matters for legitimacy. He finds the mutual consent idea too demanding here.
So what's his alternative principle?
He proposes something called the Resines principle. The idea is that government should respect the reasonable expectations it creates in people subject to its laws.
Reasonable expectations. So could someone argue that if undocumented immigrants have lived and worked here, maybe the government has created an expectation that their U.S.-born kids will be citizens?
That's exactly the complex question it raises. What counts as reasonable reliance? Has the government, maybe through inaction or even implicitly benefiting from their labor, encouraged their presence enough to create such an expectation? It's a really difficult ethical and legal question.
And this debate jumped from theory to, well, potential reality very recently.
Yeah.
January 20th, 2025, President Trump issues Executive Order 14160. What did it seek to do?
It aimed squarely at reinterpreting subject to the jurisdiction thereof. The order tried to exclude two main groups from automatic citizenship at birth.
Okay, who were they?
First, children born in the U.S. whose mother was unlawfully present and whose father wasn't a U.S. citizen or a green card holder.
Okay, that's one group. And the second?
The second group was children whose mother was here legally, but only temporarily, think student visas, work visas like H-1Bs, even tourist visas again, if the father wasn't a citizen or permanent resident.
Wow, so that covers a huge number of people beyond just undocumented immigrants.
Yeah.
What's the legal justification offered for this, say, by someone like Charles J. Cooper, who testified on it?
Cooper's argument, essentially, is that Wong Kim Ark was narrow. He claims it only applied to children of lawful permanent residents and doesn't compel citizenship for children of undocumented or temporary visitors.
And how does he redefine subject to the jurisdiction?
He argues it means more than just being subject to U.S. laws. He says it requires owing direct and immediate allegiance, a kind of full reciprocal political bond with the U.S., not something temporary visitors or those here unlawfully possess, in his view.
Did he offer other reasons? Textual or historical, maybe?
Yes, several. Textually, he argued that if subject to jurisdiction just meant subject to laws, it's redundant, so it must mean something more, like allegiance. He also pointed to the phrase, "and of the state wherein they reside," as implying a need for permanent legal residency.
And structurally?
Structurally, he brought up the requirement for the president to be a natural-born citizen. He suggested this implies a deep allegiance that would be weakened if children of, say, temporary visitors or even enemies could become president just by birth location.
Okay, and historically?
Historically, he linked the 14th Amendment back to the 1866 Civil Rights Act it was based on. That act excluded people subject to any foreign power. Cooper reads this exclusion as applying to children of aliens who owe allegiance elsewhere, meaning temporary or undocumented immigrants. It's a reading focused heavily on undivided allegiance.
So where do things stand legally with this executive order right now? Is it in effect?
No, not currently. As of mid-July 2025, there's a preliminary injunction from a court case, Barber v. Trump, that's blocking EO 14160 from being implemented.
It's blocked for now.
Yeah.
But government agencies are still preparing.
That's right. USCIS, the immigration agency, is developing an implementation plan. They're working out the details of how they would apply the order if the injunction gets lifted. This includes defining terms like unlawfully present and lawful but temporary.
Who falls under lawful but temporary in their plan?
It's quite broad. It includes people on H-1B work visas, their H-4 dependents, students on F visas, parolees, people with temporary protected status, TPS, even those with deferred action like DACA recipients.
And what happens to the children born to parents in that lawful but temporary category under this plan?
The plan suggests USCIS would let these children basically inherit the temporary status of a parent, or at least defer any action to remove them. But crucially, they wouldn't be considered citizens automatically at birth.
Now, there was also a recent Supreme Court ruling, Trump v. Casa, Inc., How does that fit in?
Ah, yes, that's important. That ruling from June 2025 dealt with nationwide injunctions court orders that block a government policy across the entire country. The Supreme Court limited the power of lower courts to issue these broad injunctions, although it didn't eliminate them entirely.
So what does that mean for challenges to the executive order?
It could mean that future lawsuits might only be able to block the order in specific regions or for specific plaintiffs, rather than stopping it everywhere at once. It potentially makes it harder to get a single nationwide halt if the current injunction were eventually overturned. It adds another layer of, well, legal complexity.
Even with the injunction in place, the idea of this change has had a big impact, hasn't it? Especially on communities like Indian families here on visas.
Oh, absolutely. Reports say it sent shockwaves through immigrant communities. Indian families are particularly affected because they dominate the H-1B visa category and often face incredibly long waits, decades sometimes, for green cards.
What are the practical worries for their U.S.-born children?
Huge uncertainty. The big fears are losing access to things like in-state tuition rates at public universities or federal financial aid for college. It puts their future education, everything, into a kind of legal limbo. It genuinely makes people question if the American dream is still attainable for them.
And the scale here is significant. You mentioned the Indian footprint in the U.S.
It's massive. Indian professionals hold something like 70% of all H-1B visas. They're vital in tech, healthcare, engineering. Plus, Indian students are the second biggest group of international students, over 200,000 in 2023.
They contribute a lot economically too, right?
Immensely. Nearly $34 billion to the U.S. economy in just 1 year, supporting hundreds of thousands of American jobs. It's a huge contribution of talent and economic activity.
So policies perceived as hostile could really backfire, leading to a chilling effect.
That's the worry. The U.S. already faces projected shortages in tech fields, for example. If skilled workers and talented students feel unwelcome or see their children's futures as uncertain here, they might not come, or they might leave. It could absolutely exacerbate talent shortages in key STEM areas.
Let's circle back to Professor Eisgruber for a moment. He had that warning about interpretive infection. What did he mean by that in this context?
His concern is that if you start making exceptions to fundamental constitutional principles like birthright citizenship, especially if those exceptions seem, well, unprincipled or politically motivated, it could damage the integrity of the entire Constitution. He fears it turns the Constitution from a document of guiding principles into just a record of political deals or power plays. It risks undermining its commitment to broader ideals like justice and equality. It makes the whole thing less coherent.
And that puts judges in a tough spot.
A very tough spot. How do you interpret an exception that seems to clash with other major principles, like equal protection? Eisgruber worries it creates a kind of gravitational force that can pull down or weaken other established constitutional norms. It makes the whole system less stable, potentially.
And given all this uncertainty and the policy shifts in the U.S., are talented people, like those students, looking at other countries more seriously?
Yes. There's clear evidence of that. Countries like Canada and Australia are actively recruiting and seen as more welcoming, with clearer paths to permanent residency. Canada in particular has become the top destination for Indian students, 427,000 in 2024.
So the U.S. risks losing out in the global competition for talent.
It definitely seems like a risk. If the U.S. is perceived as closing doors or creating instability, that talent will go elsewhere, impacting innovation, economic growth, and America's overall competitiveness.
Okay, let's try to pull this together. We've really dug into how this long-established principle of birthright citizenship, rooted in the 14th Amendment and affirmed by Wong Kim Ark, is now facing a major challenge.
A challenge based on reinterpreting that key phrase, subject to the jurisdiction thereof, pitting ideas of owing full allegiance against simply being subject to U.S. laws.
And we've seen the potential ripple effects, the uncertainty for families, especially those from places like India who contribute so much, the potential hit to the U.S. economy and its ability to attract talent, and even these deeper questions about the Constitution's integrity.
It really underscores that citizenship isn't just a legal tick box. It's about fundamental choices regarding who we are as a society and who gets to participate.
So as you think about all these arguments, the historical context, the legal theories, the human impact, here's something to consider. When we talk about who belongs and who gets a voice in a rapidly changing world, what balance do you think best serves the long-term vision of a society that is both just and responsive? All the best, and we will meet again with another important matter again.